you, Gaelic, and thanks everyone for coming before the committee today. On the optional protocol, the ratification is obviously incredibly important. It's continuously brought up by DPOs, disabled people organisations, by disabled people and their advocates, and this committee has asserted the need for immediate ratification over and over again. And frankly, the rationale that you've given for the ongoing delay I don't think is acceptable. The goalposts basically just keep shifting. So you claim that Ireland doesn't enter into binding international treaties until the state is confident that the obligations set out within can be complied with. And that is just demonstrably untrue. Every week in this committee, we hear about how the state is failing to meet its CRPD obligations, and individuals' rights are being violated all the time, and Ireland has signed and ratified the convention, even though there are glaring examples of non-compliance. So that reason is just completely invalid. We do enter into those agreements without being able to meet the obligations. We do it every day. And we've heard repeatedly from legal experts that there's no impediment to ratifying the protocol. The only barrier seems to be the government. So in summary, for a while the excuse we were given was, oh look, until the Assisted Decision-Making Capacity Act is done, we just simply can't. Now that's done, and you've given this excuse that we don't enter into these things until we can completely comply with them. But that's also just not true. We do enter into those things and we can't comply. So what is the actual reason for delaying this any further? It's my first question. I'm more after that, Chair, if that's okay.
So the failure to implement the Assisted Decision-Making Capacity Act, the 2015 Act, the fact that we had wardship in place was a clear violation of Article 12 of the Convention. So in order to undertake ratification of the optional protocol, in order to be in a position where we could reasonably say to the United Nations, we are in a compliant position, we had to take the measures to address the fact that wardship was still in place, and that was done through the Assisted Decision-Making Capacity Act. In terms of what we're doing now, we're undertaking a scoping exercise to identify if there are any other clear violations of the treaty in terms of existing elements of Irish law, so we can look to remove those violations, to address whether it's by legislation or otherwise, to make sure that when we sign up to the optional protocol, when we provide that route for people to make their individual complaints, there isn't an example of a clearly identified existing violation of the UNCRPD. So
yeah, the point I was trying to make is that there is loads of those violations of the CRPD without the optional protocol that we break all of the time. So the Assisted Decision-Making Act was the excuse for a long time, and now you don't even know what the next one is, but you're going to give a scoping exercise to figure out what that excuse is, and then we won't ratify again. That's just to translate what is happening, I presume, because it's been nearly 3 years since the election, and it took that long to deal with the Assisted Decision-Making Capacity Act. Now we're going to look and see what else we might need to deal with before we do that. So I'm presuming it's going to take that long again. In terms of the reservation, so the Assisted Decision-Making Act violates the CRPD by allowing substitute decision-making, and you've previously attempted to dispute that, and you were publicly corrected by the Vice Chair of the UN CRPD, the committee, and the legal reason that you can breach this right is because of Ireland's reservation to the CRPD concerning Article 12, and that means the state doesn't have to recognise legal capacity as an absolute right, and I don't think that's something that's really publicly known. I wasn't actually fully aware of that. But the State Party report you've submitted to the CRPD outlined that this reservation will be maintained. Am I right in thinking that? So the committee will probably recommend its withdrawal because it has done that with Canada and Kuwait and Singapore. So why is the government committed to that reservation and its limitation of decision-making rights? And how will you, or presumably maybe your successor, explain this to the CRPD committee, that we want to keep that reservation?
Well, To begin with, as you know from our discussions on the Assisted Decision Making Capacity Act, I believe the measures we've taken in that Act are compliant with the UNCRPD, and that's the position of the government in terms of the principles that are woven into the Assisted Decision Making Act, both the 2015 Act and the 2022 Act. The fact that the support for a person's will and preference is reiterated throughout in terms of how that act is interpreted and applied, it leaves the government confident that this does protect and is compliant with Article 12. I recognise you don't agree with that position. Obviously, when Ireland goes before the UNCRPD committee, the position there will be adjudicated on or discussed by the committee, and I or whoever's in this position at that point will make the case in terms of our compliance. Internationally, in Ireland, on a number of international treaties that we've signed up to, have made reservations on certain treaty articles. I wasn't here. I wasn't in this role, or indeed in the Oireachtas when we signed up to the UNCRPD. I don't have an overall sense of the arguments made at the time, but the central element that we're seeking to secure is respect for an individual's will and preference, and we believe that is secured through both the original 2015 Act, the 2022 Amendment Act. But as I say, when we have the opportunity for that hearing before the UNCRPD committee, this is an issue that can be teased out further.
Okay, so even though we can probably predict, because in the case of Canada, Kuwait and Singapore, that it was recommended that the reservation be removed because the government's position is that it disagrees with the UN CRPD committee, we'll probably just stand our ground anyway, is what I kind of take from that. So if we do hang on to that reservation, which, like you said, I don't agree with, but if we do, then under the Assisted Decision Making Act, the appointment of decision making representatives occurs through application to the Circuit Court. And this form of substitute decision making is very significant because it involves, compromising an individual's legal capacity and the rights to the CRPD. So while I have to accept that you and the Decision Support Service are happy with this situation, I'm concerned that it occurs through the Circuit Court because the judgments aren't recorded there. Another thing that I wasn't actually aware of until recently. Not that I'm saying that they should be, but in that instance then, that creates the circumstances where there can be really inconsistent rulings, because it's not like there's kind of a precedent and it's recorded and we see what, that there's some kind of a norm or a practice kind of established if it's not recorded. So there could be different standards around different districts, basically, around really crucial human rights issues, which is, at the very least, I think, irresponsible. So I'm just wondering if you can put in place, or are the department looking at that, putting in place mechanisms to ensure that there is some consistency in terms of those judgments. I know that they're not normally monitored in those courts, but in this instance, could they perhaps be monitored to ensure that there's kind of a level of consistency there and not just a complete kind of lottery on something so important to somebody?
Well, the decision was made to treat these cases, I suppose, like we treat family law cases in camera, because of the sensitivity of the issues that are being addressed. You might recall during the discussions on it, I think Deputy Sherlock raised the issue of allowing journalists to enter the court and record, and also then allowing court reporters. So we made a change in the Shannon. We brought forward an amendment that would allow a reporting system, somewhat like the family law court reporting system that operates now. So these are anonymised, but allows I suppose, an understanding of very much the issues you're flagging up in terms of different circuits in the country. So that the legislation allows for that to happen. We amended the legislation to allow for that to happen.
But is that just in relation to journalists, or will there be kind of an official record kept?
Sorry, it's not in relation to journalists. It's in relation to a kind of an academic study, and I think probably the best similarity, or what certainly I had in mind when we made the amendment, was an approach like the family law reporting system that operates at the moment in the family courts, which provides, I think, maybe annual or biannual reports on maybe 40 or 50 anonymised cases that they've attended, where they're able to give information about, I suppose, sentencing or trends in terms of rulings and the like.
Okay. And can I just ask, would it be possible for the department to relook at perhaps, like, if it's annually or every half year, whatever, that maybe just in the early stages of it, that it's done a bit sooner, to see, because then a standard would be established but maybe a year later, and then we'd still have the kind of lack of any kind of standard being applied for the first while. And I don't have the solution. I'm wondering if the department could look at that and see maybe what could be done, and perhaps we can as a committee as well, because it does seem like an area of concern if people just go into the courts and there's kind of a geographical lottery as to whether or not a right like that is taken away from you.
I take your point on board. What I would say is, we will be looking to. The Act also provides for 3 new circuit court judges to be appointed, because there's already pressure on the docket of the circuit court. Obviously, the judges who will be working on this legislation will have specific training in terms of implementing the specific provisions. But I take the point. It is important that there's consistency there, and look, we can certainly look at obviously. In terms of the Oireachtas, or indeed the government, this is a judicial decision and there can't be interference. But we have changed the legislation to make sure there is at least some element of transparency in the outcomes of these decisions.
Thank you.
Emer Higgins.